prayers, and we wish him all the best. Now, with that, ladies and gentlemen, it gives me great pleasure to introduce our moderator, Mr. Kamal Shah. Kamal is a partner at Stevenson Howard and based in the UK. He's now based in the UK, and he is a Kenyan by roots. He is a great supporter of EAC. He has been a mentor to me and to many other lawyers. He's very, very passionate about mentorship, and his profile, you saw it on screen. He has been recognized by leading international bodies that recognize leading lawyers in the arbitration and energy sphere. With that introduction, I now hand over to you, Kamal, to introduce your panel and to also set the scene for this energy development and disputes webinar. Thank you.
Thank you, Warimu. Good afternoon, everyone. Pleasure to be here, and thank you very much to the whole EAC committee for inviting us and for putting today on. They have, as always, got the timing right in perfection. England won last night against Denmark, so it's an even bigger occasion for those of us who support England. So thank you for that prediction as well. I have the pleasure of chairing a very eminent panel today, and I will start by introducing them briefly and leave you to read their illustrious bios online, and then set the scene with a few statistics and give you a high-level view of the energy footprint Africa currently enjoys before handing over to each of the speakers. So in order of speakers, we have first Gadi Ndahumba, who is the head of the power sector at the Africa Legal Support Facility, the ELSF. Gadi is responsible for the coordination and implementation of ELSF's transactional support to numerous African governments and utilities for the development, the procurement, and the financing of power sector infrastructure projects. And prior to joining the ELSF, Gadi was with a top-tier Canadian firm, so he brings both the private and the public sector perspective today for us. He will be talking about the power sector contracting by governments in Africa and how the ELSF helps with technical assistance and go on to talk about the main causes of power disputes as he sees them. After Gadi, we have Elodie Dulac, who many of you know. She is a partner with King & Spalding in Singapore. Elodie has represented clients in commercial and investment treaty arbitrations around the world. And in addition to her work as counsel, she has been appointed in a number of arbitrations as an arbitrator under a number of different rules. In addition to that, she also finds the time to lecture at the universities of Addis Ababa and Bahir Dar in Ethiopia, amongst her many other activities. She is here to talk about common disputes, elements in oil and gas projects in Africa, and share some of her perspectives as well. After Elodie will be Ahmed Rufai Khalid, who is the general manager of the litigation, arbitration, property and environmental law team at the Nigerian National Petroleum Corporation, or NNPC in short. Khalid has been with the NNPC since 1992, having had a number of different positions from chief legal officer in the midstream sector to the upstream sector, and currently progressing towards being the general manager of the litigation, property and environmental law department at NNPC and Abuja, which is the headquarters of the corporation. He has, as you would expect, participated in numerous negotiations and arbitrations involving the NNPC with multinational companies on the other side, both in and out of Nigeria, and brings a huge amount of experience from the government perspective to the table today. He has proudly been part of several negotiating teams which have saved the corporation and other related entities from huge liabilities totaling several $1 billion. He will be sharing the Nigerian experience, as we call it, in oil and gas, and lessons for other countries and pitfalls to avoid when negotiating contracts and in implementing and managing how contracts evolve. So with that in mind, I want to just set the scene with a few opening slides before handing over to what you have really come to see today, are the panelists. Steve, if we could go on to my slides, please. We should have them up in a minute. Thank you. Perhaps you go on to slide 3, as I've just done the introductions to the panelists, please. Thank you. So by way of background, I just want to touch on Africa as a whole, both in the oil and gas sector and the power sector. The numbers that you will see there are very stark and quite an eye-opener. In terms of oil and gas, Africa accounted for about 9.5% of global crude output in 2019, and around 4% of global LNG output in the same year. As you would expect, the 3 main producers are Nigeria, Algeria, and Angola. But the point I want to make here is if you look at these stats, which are impressive enough, and if you combine that with the untapped potential, both in oil and gas and in other areas, there is still a substantial growth to come. And that I hope you bear in mind as we progress through this seminar. On the power side, across Africa, if you look at 2 periods from 2000 to 2013, and from 2014 to 2019, the number of people who have gained access to electricity have doubled to almost 20 million each year. So again, there is a growing positive story of access to electricity and therefore development in a wider scale. And this growth in access to electricity is particularly relevant for East Africa, especially Kenya and Rwanda, which I'll come on to in a moment. Steve, next slide, please. So drilling down to East Africa on the oil and gas side, there are several East African countries who are in the race to become new oil economies. We have Kenya, South Sudan, Tanzania, and Uganda, who are all laying the groundwork to join the ranks of the oil exporting countries. Some of the main issues that they will face and are currently grappling with are difficulties in securing funding for developing production facilities and for exploration efforts. Another difficulty they are grappling with will be establishing a legal and regulatory framework that works both for these countries and also the foreign investors who are combining their resources to exploit this. And there, as we've seen in more mature oil and gas markets, this is a ripe area for misunderstandings and occasionally disputes as well. Another difficulty is finalizing commercial agreements, which can take months and sometimes several years to do so with foreign investors, and again, give rise to a number of misunderstandings and disputes, as we'll no doubt hear from some of our panelists today. Next slide, Steve. Looking at West Africa, again in the oil and gas sector, most of the proven oil and gas resource is in Nigeria, as we know. But even there are emerging economies in Ghana, Senegal, who are known to have significant oil reserves, both discovered and undiscovered, amongst other economies. Crude oil production in West Africa is expected to almost double in 2024, which is driven by the rise in consumption and rapid infrastructure growth across Africa. So it is still yet to come. And despite that, there is a growing awareness that these oil economies must decrease their reliance on oil and gas. And what we're seeing is a rise in cooperation between the states who are focusing on decreasing oil and gas reliance and looking at other renewable methods to produce energy and other forms of power. Next slide, please. So let's talk about power in East Africa. Many East African countries have significantly increased their power generation capabilities in recent years. There have been a number of regional collaborative efforts, which is great to see, to connect electricity grids, to share excess capacity, and to set up power trading platforms where there is excess capacity as well. And one of the initiatives, as is mentioned there, is the Eastern Africa Power Pool initiative. The success in power connectivity is likely due to a relatively strong infrastructure development, which has been built up over the last few years in East Africa. An example there is the Ethiopia-Kenya transmission line. And of course, all of this is good news to multilateral funders like the World Bank and the EU financial support, who are pumping in money into this sector. So over the next 5 years, 10 years, we will see growing efforts here, which is going to mean that there'll be a more balanced reliance on power production and energy production. If we look at West Africa, up to 70 to 85% of the population today in some states is still relying on traditional biomass as a source of electricity. And of course, we know power outages are a common occurrence. But there again, we are seeing good collaborative efforts to help with getting away from oil and gas. And the ECOWAS has been working hard to set up a common market for electricity as well. And there are recent trends in wind and solar, which are listed there in some of the countries which are looking to exploit good wind corridors and the fact that there are many hours of sunlight in a day to tap into the solar market as well. So what does all of this mean for those of us who are disputes lawyers? It means that there will be disputes, of course, and misunderstandings, and it gives rise to a number of different types of issues, both on the commercial side or where you have governments involved, investment treaty style disputes, and contractual claims. Of course, we see all the time there's faulty construction issues around joint operating agreements, service contracts, and of course the growing, the rise in tax-related investor state disputes. And we have a few examples already in the past 5 or 10 years, which have led to significant amount of litigation and of course arbitration. In terms of geopolitical disputes, this is also a growing trend. And if we look at just the River Nile, which has caused a number of issues, there are 10 countries or so going along the Nile. And the most prominent one currently is the Grand Renaissance Dam built by Ethiopia, which is creating some tensions between Egypt and Ethiopia and some of the other countries who enjoy the waters of the Nile. And this is a project which I can see growing in terms of misunderstandings and disputes. And we've already seen some coverage on that, and it continues as we speak today. So with that short introduction, I would like now to turn to our panelists and hand over to Gadi. But before we do that, I believe there is a poll coming up shortly. There we go. The first poll. Please vote. What do you think most contributes to investor-state disputes relating to energy or other sectors in Africa? Is it poor contract negotiation and drafting? Or is it poor contract performance management or political influence and interference? Over to you.
Thank you, Kamal. Stephen, can I have the slide? Just in a few seconds.
I hope we have the results of the poll before we move on. There we go.
Interesting.
So it's fairly balanced. Thank you. Gadi, over to you.
Thank you, Kamal. Hi, everyone. So my name is Gadi Ndahumba. I'm the head of the power sector at the African Legal Support Facility. Kamal described my profile really quickly, but I do want to put emphasis on the fact that I'm a transaction lawyer. So I had the portfolio of projects across the continent in the power sector for the ELSF. But we do see potential for dispute or disputes as well. If you can go to the first slide, please. The second, yeah, thank you. So I'll start by a brief, and I'll be brief, description of the ELSF, just to explain a little bit the perspective that we have on the market. The presentation will be focused on the power sector, since oil and gas will be covered in the two other presentations. So the African Legal Support Facility is an international organization. It was developed and it's hosted by the African Development Bank. We're in the same buildings, and we do share facilities, but we do have our own board, and we operate in parallel. So we have a membership composed mostly of African countries, 5 non-regional as well. So Belgium, UK, Netherlands, if I remember, the Netherlands, Belgium, France, and I'm forgetting one, but so apologies for that. We also have some international organizations that you can see on the slide, and our beneficiaries are basically all African countries. So most of them are members, but even if the country is not a member, they can benefit from the support of the ELSF. We provide support to governments, but the broad definition of governments, so that includes government agencies and state-owned enterprise. Next slide, please. So the objective of the ELSF is to reduce the asymmetry in technical and legal capacity between governments and international investors or developers in the context of the negotiations of complex commercial transaction, and as well litigation. The ELSF was initially established because of the wave of vulture fund litigation, but quickly it was established that a lot of these litigation were based on contract which was unbalanced, not properly negotiated. So the ELSF increased its scope to include support for the negotiation of these project contracts, sovereign debt issuance, and things like that. So we have key sectors, and we have 3 different types of activities. We have the advisory service, which is the main activity. The most projects are advisory service projects at the facility. So we provide the government with experts, almost always law firms, but also sometimes technical and financial experts, to help them negotiate the commercial transaction, or to represent them if there is a dispute related to it. We also provide capacity building support along the side, typically with an advisory project, but we also have standalone capacity building project, which includes one of our most recent continental initiative, which is a platform called the ELSF Academy, which will have classes, courses, online courses available to everyone who registers. It is focused on the key sectors that I will describe quickly after this, but it's also the kind of content that will be really useful for government officials and also lawyers across the continent. We also have some knowledge management projects, including the AMLA APLA platform, which will have legislations of all African countries for mining or oil and gas, and you have different tools on this platform, like the ability to compare different legislations. The ELSF focus on its assistance on a few sectors. So the sectors are listed there: infrastructure and PPP, and the power, transport, water, sanitation, and other infrastructure sectors. We also do natural resources and extractive industries, extractive industries in the broad sense. We include, for example, wood or fisheries when there is a concession. And we also support for sovereign debt management from the issuance to creditor litigation. The common thread in all of these sectors is actually a long-term relationship with the private sector. So when a PPP is established, or when a mining concession is established with royalties to the government, for example, or sovereign debt issuance, it's going to be a long-term relationship with the private sector, which has a lot of potential for disputes. And this is why the ELSF comes in to provide support to ensure that the government will be adequately supported and will reach a balance and fair agreement, which is really important, especially since governments are likely to change during the time of the concession or the contract. Next slide, please. So, sorry about that, the wind. So I'll focus mostly on the power sector, although we intervene in other sector, but for the purpose of this presentation. And what we're seeing in the sector at the moment across the continent is really a reshaping of the African power sector. The reasons are multiple, obviously, but one thing we see is many jurisdictions in which we work have the first IPP project that is being developed or financed, or a significant increase of IPP project. IPP project being the independent power producer. So it's the generation of electricity segment of the power sector, which has been gradually privatized in the last 2 decades, but there was still a lag to have the first projects actually being developed and financed, and we see that quite a bit at the moment. We have 7 different countries in which we're working on the first IPP. The IPP means that it will be a private sector actor who will own the power plant and will sell the electricity to the utility. Obviously, these projects involve really long-term contract between the private sector and the government, or it's SOE, the utility, and most likely both. So obviously, potential for dispute there. We also see some privatization and nationalization evolution of country sectors. Privatization is something that has been happening, I would say, for the last 3 decades at different pace. But we also see nationalization, so concessions that have been terminated and the assets that are reverting back to the government or the state-owned utility, and that actually has a lot of potential for dispute as well. Growing electricity deficit. So Kamal did mention that the number of connections are doubling. It's true, but the deficit is actually increasing because of the demographic trend, and also the number of projects is drastically increasing because now with the renewable wave we have smaller projects, and that increase the number of projects in each country that can be developed. Most of the invested capital now in the sector, and when I say most, it's really most, is from foreign developer and investors. So we will see a lot of agreement with international arbitration clause in these. So I can sum up by saying that there is a general increase of the potential of arbitration cases with African states in the power sector across the continent. That's what we're seeing at the moment. Please, next slide. So in the documents or the agreements, I should say, for these kind of projects that we see, we have obviously the power purchase agreement, which is the agreement with which the utility will buy the electricity from the private sector owner of the power plant. But typically along the side with this agreement, you will have some government support agreements. And I put S because it depends. It can be one or many, or one that actually covers some of them. So the implementation agreement, for example, can have a sovereign guarantee within it. The project development agreement can be included as well in the implementation agreement. And the big difference between these two is that the second category, so the government support agreements, will be signed with the government. it's a lot more difficult to enforce an arbitral award against the utility because the utility's assets will be mainly in the host country. So typically you'll see GSAs, so government support agreements, signed along the side, and these will be enforceable against all the assets of the government. So there is definitely a risk there, but also more potential for international arbitration there. The third category is the concession agreements, which you could see in IPP projects. So the IPP project will have a PPA, so the power purchase agreement, and GSAs. Sometimes the GSA will be replaced by a concession depending on the jurisdiction, but the concession agreement is a much broader scope and can include privatization of some segment of the power sector. A lot of potential for dispute there because there will be some KPI. So yeah, it's something we're seeing at the moment. The MOUs, I just mentioned it because we're seeing a trend at the moment where some developer intend to have MOUs that are binding with a full-fledged arbitration clause in it. It is atypical, and we do not advise the governments to sign a binding MOU because it should just be a full-fledged agreement if that's the case. But we're seeing it more and more with explicit language to the effect that it's binding, and that is often misleading for the government who just wanted to express its will to explore a partnership with the private sector participants. So that actually could lead to an arbitration case, but it's yeah, we don't advise to do that. We also see a really big difference between what I call DFI-led projects versus the non-DFI projects, DFI being development finance institution. So when a DFI is involved in the project, the kind of dispute and the way the disputes will be managed and the likelihood of this dispute to actually reach arbitration is much lower. The dynamic will be a lot more political. There will be a lot more meetings between the DFI, although the DFI might be just a lender in the project. But they will have meetings with the government to try to solve the issue, and obviously some soft power applied to try to solve it without going to arbitration. So it's actually quite rare to see a DFI-led project go into arbitration. It does happen, but it's a lot more likely with non-DFI projects. And the non-DFI projects used to be quite rare in the power sector across the continent, but now are increasing drastically because of the size of renewable projects. So you have a new dynamic in the disputes resolution processes that is establishing itself, just because these projects are not supported by DFI who can use soft power to try to solve the issue. We also see that African states are actually seldom the claimants in an arbitration case that we're seeing at the moment. It is much more the private sector who will make a claim. And what we're seeing, which is really interesting, interesting and a little bit worrisome, to be honest, is that we see that the governing law in many of these agreements will be not the host country. So the ELSF will always advise to, although you have an arbitration clause and the ability to deal with a dispute outside of the jurisdiction, to still apply the law of the country. That's not always possible. It depends of the legislation framework. It depends of the flexibility of some of the lenders. So sometimes it's not possible, and we'll see UK or US law or French law being applied to an agreement in an African state. That is a bit of an issue because most of these countries have case law where the government is seen as an entity in a position of power. So a lot of presumption or a lot of the decisions were made on that basis. On this continent, it's quite the opposite. The sophisticated and more resourceful party is often the investor, the foreign investor that comes with a full set of legal team. And this is where the ELSF is really important. But the case law in these jurisdictions is kind of problematic when you're applying it to a dispute where the parties actually do not have the same dynamic as they would have in these jurisdictions. Thank you. So the typical disputes origins, definitely the procurement and the sourcing. The lack of capacity in some countries means that they have a lot of unsolicited bids. The unsolicited bids or developers that will approach on their own the government for specific projects. It is possible to bring a good project from an unsolicited bid, but there are a lot more risks, and this creates some issue which with respect as to whether the agreement was adequately procured, whether the signatory had the authority to sign the agreement. And we see cases of that. And the problem is if the agreement is signed and the private sector participant can bring an arbitration claim, even if it was not correctly procured, and the government cannot move with the project because it was not adequately procured. So you really have some issues there that we're seeing, and also to be transparent, also sometimes corruption will enable a developer to have the signature on his contract, but we don't know how they actually got it, and ultimately there's still sometimes considered a valid contract between the state and the investor, and this is really an issue. The performance, the performance obviously of the contract is a potential for dispute, but what we're seeing the most is actually in a non-performance in the project development phase of the project of the government to satisfy some obligations, for example, with respect to permitting or to making the land available. So the really beginning of the project development obligations. And this is an issue because you start creating arbitration cases or at least disputes on projects that are really at the beginning of their evolution. So the government might have signed way too many agreements and then has to cancel some at the early stage and will be on the hook for some of these agreements. The non-payment does happen, so the utility not paying for the electricity, but it's a lot more rare because once the utility is receiving electricity, there is a codependency and they need the electricity, so the willingness to solve the dispute is much higher, although it still happens that we have issues. What we have seen quite interestingly, and maybe that can be discussed more in the plenary just after, but we've seen some agreements that are not properly signed, like so authorized, approved. So for example, a jurisdiction where cabinet approval would be needed, and the notification within the government, including the service notification for the arbitration case, is to the signatory, so to the office of the signature who didn't have the proper authority to sign the agreement. And this is kind of a loop now, because there might be a failure to appear from the government where they actually ultimately were never properly served. So we do advise, especially if you're representing the non-state party, to serve fully in accordance not only to the contract but also to the African state laws. And I would go in for even further, the jurisdiction in which you're having the seat of the arbitration, just to make sure that the government is actually aware, because there is definitely instances where they were not properly served, or they were served but only one part of the government, and often there is a lack of capacity. That means that it can take some time before they actually react. So this is a really big issue, we are sensitizing the governments to the importance to appear in court and to respond to any arbitration notice they receive, and to avoid having an award by default. And I would end on a note of caution, or a word of caution. We ultimately are seeing some vulture fund type of litigation or arbitration case at the moment using power sector agreements. And this is really, really worrisome, because the arbitration process is a really important element of foreign investment. But if African states feel that they were really being trapped into proceedings that they cannot respond to, and we're seeing cases where the investor will start seizing assets to, like, across the world, so it costs a lot of money. So this is something we can discuss a little bit more, but African states are definitely not the dominant position or dominant governments that you see in Western countries.
Thank you very much, Gadi. That's fascinating, and we'll come back to you. I certainly have some more questions on the role ELSF plays. Can I hand over now to Elodie? Over to you. Thank you.
Thank you, Kamal. So I'll discuss some type of disputes, oil and gas disputes in Africa. I don't plan to be exhaustive, because as Kamal mentioned, there can be really a universe of types of disputes in the oil and gas sector, whether like purely contractual disputes, service agreements, joint operating agreements, construction contracts, and then the disputes with the national oil companies, the host states, under PSCs, concession agreements, and the investment treaty arbitration, where oil and gas is a sector which is one of the sectors giving rise to a large proportion of investment treaty disputes. This is not specific to Africa, but it's definitely seen in the Africa investment treaty cases. So I just focus on some areas which are fertile or may become fertile for oil and gas disputes in Africa. The first one is disputes arising out of changes to the regulatory framework. And that can be changes, for instance, to something quite like common in this type of disputes, it changes to a tax regime. It can be changes to a tariff. You have a tariff like in a contract, and then the government is going to issue a decree or regulation, unilaterally amending the tariff, overriding the contractual mechanism to amend the tariff. It can be cost recovery issues, where you have a cost recovery in your PSC, and then the government may issue regulations excluding some items from cost recovery after you enter into your PSC. So there can be a variety of it can be a law, a regulation, decree, whatever the form of the government act. And to make it short, I refer to a law, but it can be basically whatever the government enactment may be outside of the contractual framework, which is going to significantly affect the contract. So how do you deal with that, with these external changes? There is a commercial arbitration aspect of it. Very often, if you have a contract, PSC, concession agreements with the host state, with an NOC, the law governing the contract will be the law of the host state, meaning the law at issue which affects the contract is part of the governing law of the contract. Even if it's not, you're operating in that country, so in most cases, contractors will, these provisions will be mandatory law in the country, so contractors will comply with them. And then that's where arbitration come in, is you may need a determination as to whether that new law, that new regulation actually applies to your contractual relationship, and even if it does it give rise to compensation, to a liability on the part of the host state? And here, I mean, you have to look at your contract, but there are different tools which can be seen in disputes. One, if you're lucky to have one from the investor perspective, is a stabilization clause. So does the contract contain a stabilization clause, meaning it can be multiform. It can be sometimes a clause freezing the applicable law to a date of signature of the contract. The clause will say like any law after that won't even apply to the contract. So to give an example from a Sonata contract, it can read the law applicable shall be Algerian law as in force as the date when this contract is signed. What is more common is what's referred to as economic stabilization, which means you would have a provision saying that the parties should like amend the contract if the contractor is in a worse position following the new law or regulation. So to, again, take language from, for instance, an Angola PSC, this type of economic stabilization clause would read, in the event of that any change in the provisions of any law, decree, or regulation in force in the Republic of Angola occurs subsequent to the signing of this contract, which adversely affects the obligations, rights, and benefits hereunder, then the parties shall agree on amendments to the contract to be submitted to the competent authorities for approval so as to restore such rights, obligations, and forecasted benefits. These provisions, of course, stabilization clauses are not systematically found in contracts, but if they are, they can be a powerful tool. They have been enforced by arbitral tribunals. Notably, there have been landmark cases in the 70s against Libya, where several tribunals have found that nationalization of oil concessions by Libya gave rise to a violation of stabilization clauses and to liability and obligation to compensate. There was also more recently a case against Mali, where the tribunal upheld an arbitration stabilization clause and found that a new legislation enacted after the concession agreement didn't apply based on the stabilization clause. So you may not have in the contract a stabilization clause. Other tools which may be available are in some contracts, representation and warranties. You may have an undertaking by the host state, a representation and warranty that the contract complies with the law. If a new law is enacted and the contract is not compatible, is in violation of that law, then that law may apply, but it triggers a breach by the host state of the representations and warranties or of the counterpart. And that won't prevent the application of the law necessarily, but that will give rise to compensation. And you may have other depending on the contracts, you may have other contractual provisions like tax allocation provisions, which means whatever new tax law, there would be a private agreement, like a contractual agreement on the allocation of the tax liability. And so the issue will be enforcing that tax liability as between the parties, irrespective of what the new law is. And of course, that's commercial tools there may be, but then there is, of course, investment treaty arbitration. And I'll come to that a bit later, but changes changes to a regulatory framework are like a typical example of what triggers an investment treaty claim. And so that was like one area, like the changes of the regulatory framework. I'm going to move to another sector of disputes, which is more like a sector which is, so to speak, becoming ripe for disputes, even if it's not generating yet a lot of disputes. It probably will generate some disputes in the coming years, which is the area of decommissioning and ASR, abandonment and site restoration, whether for onshore, offshore facilities. This is, and especially like in West Africa, some PSCs are going to expire or fields will arrive to the end of their life. So it's an area which has a potential of generating disputes, and we've seen it in Asia, where maybe they, so some PSCs, this situation has arisen like a first wave of PSCs fields have come to the end of their life, and the abandonment, the thorny abandonment issues have come up. So why is it an area of potential disputes? First, because the PSCs or concession agreements, which are decade-old, are often silent on decommissioning obligations or standards. It's more like a recent phenomenon. So you may have, and often now you have, national laws which have or regulations which have been enacted over recent years after the execution of the PSCs which are going to expire, which set forth a regime for abandonment or decommissioning. For instance, Angola issued a decommissioning law in 2018, which set forth an obligation to set up an abandonment fund. It's also like, so there are multiple potential issues. First one, and that comes to the point I was discussing earlier in the change of legislation, is that you have new law enacted after your PSC was signed, imposing new decommissioning obligations, which are very costly. So there is a question of, do this law apply? To what extent? So that's one area. The first is the interaction between the old PSC, which didn't have these obligations, and a new law bringing them in. There may be international law issues, because under international law, the owner of the petroleum facilities has a liability for abandonment. And often the government, at the end of the life of a PSC, will hold the title, become the owner of the facilities. So that raises a question, and should the government, as the owner, have the abandonment liability? And then there are implementation issues, because if these obligations are new, like setting up an abandonment fund, under a PSC, you may not have enough years of production under the PSC to actually cost recover the amounts you have to put in the abandonment fund. And then there are issues as well, because these laws, a number of these laws haven't been actually tested in practice. And there are questions about what would be the surviving environmental liability. If the assets are transferred, what's the allocation of liability between the original contractors, the successors, which may be an NOC, which may be another company. So there are a variety of issues which can and which they have given rise to disputes, because also of the amounts involved. And the fact that in most cases, this wasn't anticipated like decades ago when the PSC was entered into. And I'm going to move to a third, last areas of disputes. I mentioned it earlier. It's investment treaty disputes. So as in other region, oil and gas sector generates a large proportion of investment treaty cases. To give examples, and usually it would be expropriation claims or fair and equitable treatment claims, especially legitimate expectations. If there is a change to the unstable legal framework or affecting the investor, like legitimate expectations in a contract, which can be a PSC. Examples, to give examples of disputes, investment treaty cases, which have arisen. There have been cases, for instance, against Uganda, about a new tax regime, arising out of a new tax regime. Disputes arising out of termination of contract, of a concession contract, for instance, or revocation of licenses. Other examples, like transferring a contract, the host state transferring a contract to another entity. And various interference with productions, for instance, cutting a gas supply line, and then a production plant can no longer function. So these are like examples of disputes which in most cases would happen by conduct by the government outside of the contractual framework, And really, you have to resort to an investment treaty to seek a remedy in these situations. Now, the tricky part is that compared to other regions, there are not that many, the network of investment treaties in Africa is not very dense. And especially a large proportion of investment treaties signed by the African states haven't entered into force. To give an example, Nigeria has signed 31 BITs, only 59 force. Ghana has signed 28, only 9 are in force. So that raises a question of what's called investment treaty structuring, or a more pejorative term for it is treaty shopping, which is basically you structure or you restructure your investment to make sure you fall within an investment treaty. So the way it is done is you look at the home state of the investment, the host state where you're making the investment. Is there an investment treaty? Is it a good one? If the answer to either question is no, then you look at the other investment treaties of the host state to find a good one with a country in which you would incorporate a vehicle to channel your investment. Often it would be a special purpose vehicle. And you do that exercise in conjunction with tax, because the country chosen has to work as well for tax purposes. To give an example of a practical example, if you have, for instance, a French or South African investment in Ghana, there is no Ghana BIT with France or South Africa. So what the way structuring or restructuring would work is that, for instance, you could incorporate a company in the Netherlands, which has a BIT in force with Ghana. And that way, the investment of the French or South African company in Ghana would be protected through this intermediary company falling within the scope of an investment treaty. This practice has been held permissible by arbitral tribunals with two caveats. It has to be permitted by the investment treaty. So if the treaty contains language which excludes special purpose vehicle, that won't be possible. But most treaties and African treaties would just refer to require incorporation of a company or the company to be constituted in accordance with the law. When you have this kind of language, it's perfectly feasible to have a special purpose vehicle and benefit from the treaty protection. Second limitation is timing. Tribunals have found that this kind of restructuring or structuring, when the dispute has arisen with the host state, or even when it's foreseeable, is an abuse of process. So it's only legitimate to do this if you do it before the disputes become foreseeable. Meaning in practice, you need, ideally, you do this when you make the investment, or when you realize like you don't have it, you can restructure. But the cutoff time is you shouldn't wait until the dispute is foreseeable. And that concludes the overview of a few areas of disputes I wanted to cover.
Thank you, Elodie. Quite a lot there to take in, and I've got some questions which I'll come back to you a little later. I'm sure others do. Can I hand over now to our third and final panelist, Khalid from the NNPC. Khalid, over to you.
Thank you very much, Kamal. Please don't have the slides. My presentation is on oil and gas disputes, as recommended by the panelists and the organizers. And I will particularly discuss on one case that will be able to showcase most of the things we will need to know about disputes in Africa, particularly in Nigeria, and how we were able to resolve the disputes. Can we still go to the next slide, please? Next slide, please. Well, we can dispense with this slide. It has to do with introducing my own person, which has been done by Mr. Kamal. That I have 30 years of law practice, and I have been around NNPC all these years, where I am presently the General Manager Litigation, Arbitration, Property, and Environmental Law. Let's go to the next slide. So the topic for discussion really will border on one case that has lasted for a very long time, since 1994 precisely, which is IPCO versus NNPC. This case arose from a contract which we call the construction of Bonny Export Terminal. Bonny is in the southern part of Nigeria, and the export terminal is one of the terminals we use in exporting our various hydrocarbons. Hydrocarbon in this case means crude oil as well as gas. So NNPC executed the contract with IPCO at a contract sum of $251 million plus $34 million provisional sum. The provisional sum is supposed to accommodate some of the specific items that will be covered by the contract, some fixed cost items. And the duration of the contract was to last for 2 years, or precisely 24 months. But eventually, the contract took another 22 months longer. So we already had issue of breach as far as duration of the contract is concerned. So one of the major issues that we had in this contract, first and foremost, was the issue of duration by an excess of 22 months. The next slide. Now, as the contract progressed, there was full compliance with the contract terms at the initial stage, and on the basis of that, NNPC was able to pay the contract sum of $251 million, as well as the provisional sum. The provisional sum payment implies that we were able to carry out all the specified aspects in the contract, as well as accommodating the prolongation costs. The prolongation costs and some of the variations, after being accommodated, made the contract to get to $302 million, which was finally paid. But we envisaged that we would have a problem with the contract right from the conceptual stage, because the bid itself was a bit late compared to other bids that came in. Nevertheless, for some other reasons, the bid was accepted by the government at the time, analyzed, and eventually the BET contract was awarded to IPCO. But after they awarded the contract, there were a series of attempts by IPCO to modify the original scope of the contract. Now, when a contractor tries to modify the scope of the contract, of course, one of the things that will come into play is that there are chances that there will be variation as to cost, there will be variation as to scope, and ultimately there could be disputes that could be that could arise therefrom. The scope of the contract should be drawn by the employer in all situations and not by the contractor. But in this case, IPCO wanted to redesign the contract, probably because they envisaged that we would resort into disputes. Now, on 26th of February, because the contract has also provided arbitration to come before litigation, IPCO instituted an arbitral proceedings against NNPC that due to the variation in scope, due to prolongation of the contract for additional 22 months, NNPC should pay it about $176 million. As I said, initially, there has been consistent attempt by IPCO to ensure that the review or vary the original scope of the contract, which ostensibly was meant to accommodate this arbitral issue. Now, when this arbitration was filed in line with the agreement, which provided arbitration instead of litigation, NNPC also counterclaimed that there was also a breach on the side of the contractor for being unable to deliver the items within the specified 2 years period. In other words, the prolongation being complained of by IPCO was also being complained of by NNPC on the other hand. But on October 28, 2004, there was an award that was issued against NNPC that IPCO should be paid $152 million plus 14% interest until that payment is made. As I said, the claim essentially was on variation as well as prolongation claim. Now, this arbitration dispute lasted for 13 years, with Stephen Harwood being led by Kamal Shah, handling the matter on behalf of NNPC. And on the local council, we had Babalaki Nonko. But NNPC, being dissatisfied with the award, approached the Federal High Court in Nigeria, challenging the arbitral award and insisting that it should be set aside. And the grounds for setting it aside were also enumerated in our particulars of defense, which you have submitted. One of them is that there was an improper procurement of the award because the arbitral tribunal was misled. There was also fraud. IPCO had committed a series of frauds in terms of documentation and misrepresentation, on the ground of which the arbitral tribunal awarded the gave the award in their favor. While Federal High Court was looking at the application for the setting aside of the award, IPCO now proceeded to United Kingdom, seeking to enforce the award, even when it was already being challenged here in Nigeria. So we had two issues. We had issues of enforcement to contend with in the United Kingdom, just as we had issues of application for stay of enforcement here in Nigeria. But eventually the enforcement proceedings were suspended because of the issue of fraud that was introduced. Usually in enforcement of arbitration or enforcement of award, once the issue of award of fraud is introduced, it sets aside the award until those issues are dispensed with. And so that was, can we go back to the last slide, please? Yeah, I was talking about the last one, that the enforcement proceeding was suspended when the issue of fraud was brought, but eventually it was settled in 2018 in favor of NNPC, that there was indeed a clear case of fraud, and because of that, the arbitral award that was earlier issued was dispensed with. The whole trial lasted about 68 weeks. And so when the issue of fraud was discovered, parties had to come back to resolve the issues within themselves, but not on the terms as enumerated in the award. And so instead of NNPC paying about $400 million US, it ended up paying less than $40 million, just about $36 million. And then some terms of settlement were signed, and then the matter was concluded. So the major lessons that we have learned from this contract is that, yes, in a contract would typically have different scenarios. I mean, you could have a contract that typically should have been an arbitration contract, but will ultimately end with litigation arising out of that arbitration as in the circumstance. But the most important lesson is that we need to carry out pre-contractual due diligence. We need to be able to know the kind of contractors we are dealing with. So this is a very big lesson, that anybody that is entering into a contract should be able to know or appraise the capacity to contract, the feasibility of the proposed contractor. And then the outcome of that due diligence should be shared with all the stakeholders before you enter into any contractual relationship with the prospecting party. And then, of course, the clauses that we're going to draft in the agreement should be unambiguous. It should be concise in order to bring in any ambiguity or complexity that the contractors could rely upon. In the circumstance, if we try to rely on the issue of duration, on the issue of commencement, and of course, they were also wanted to arbitrarily misuse the provision for arbitration. So we'll go to the next slide. Yes, from the previous slide, we also need to carry out the due diligence on the funders, anybody who is going to finance the contract, because some of the funders are also there to make undue promises or undue advantages or undue profits where it is unnecessary. And the other one is that we also need to have experienced and appropriate lawyers to be able to prosecute issues arising from or in connection with the contract. And how do you get experienced contractors? You actually get them from the very conceptual stage. In other words, when you propose to enter into multi-currency or multinational contracts, you need to have very, very reputable lawyers that you will do all the reviews together so that they will be able to have the background knowledge of what you are venturing into and being able to advise him. That's the first part. This is the first part before you talk about litigation. If it turns out to be a litigation arbitration issue, the choice of counsel that will be able to defend you is also very, very important. In this case, being an international arbitration, you need to have a very robust and sound local counsel. You also need to have a very robust and sound local foreign counsel. We are lucky to have them both in this case, and that was why we could proceed with the matter for 13 years and eventually pay about $36 million out of $400 million claim. So we should also be having a periodic case management review and some legal advisory services, all of which you can only get if you have very sound lawyers, both the internal lawyers as well as the external counsel you will seek to have to represent you in your various arbitrations as well as litigation. So go to number 3. Yes, in IPCO's case, we had very, very complex documentary issues. The documentary issues gave us a lot of stress because of the different filing system and all that. So one of the lessons we have learned here is that it is very important that we will have documents that are easily retrievable, that we'll have access to, and we should also be able to spread the risk by ensuring that all the respective parties in a contract have access to these documents for ease of retrievability as well as record keeping. At one time, we had to spend about a month in a warehouse searching for very relevant documents, especially where we had costs to really establish the case of fraud. It's not easy to just say there is a fraud. Then it is not easy also to be able to establish it. So it's a great lesson we have learned that we have streamlined our records. And of course, another one is a training. We've learned a lot on this, that for every contract that is typically a project-driven contract such as this, the parties or the players should be going through training and retraining. We had costs to be having testimonies, having expert opinions and all that. And we have realized that the training that these persons have had helped greatly, but we will have also done better if they were given further training and retraining. So it's now a policy that each time we are indulging into these kind of projects, we should be able to build in robust training as a one. Of course, we also have a contract management, a policy and procedures on how to carry out contracts. And it has become one thing that could lead to a consequence management, one thing that could lead to penalty against the contract managers to accommodate variations where variations are not necessary. In other words, if you are going to scope a contract, you should have a front-loaded contract that is comprehensive enough to accommodate all that is necessary for the execution of that contract. Because variation, in most cases, is corruption. Variation is another means of usurping or asking for additional monies that are necessary. So we ensure that the project team should be able to give a very comprehensive scope that will accommodate and which will not give the contractor the opportunity to ask for any variation. And of course, involving the legal department. Virtually all the contracts now in our government agencies, particularly NPCC, will always have a representation from the legal department at the conceptual stage. Not when all has been done, then you will now ask the council to draft the contract. No. We are involved in all the contracts, and we give on-the-spot opinion or corrections where necessary at every interval. And so we were able to protect or secure all the loopholes that could arise out of or in connection with the contract. Of course, I've mentioned it earlier, the issue of robust contract drafting. Our contracts are drafted, redrafted, and of course we give it to the engineers. They look at it, and we make sure that all that is needed, necessary to protect the government agencies or NMPC, as I said in particular, are embedded. So we actually do not even envisage to have a case such as IPCO, given the watertight kind of contract that we've been having. The next page. I don't think we have any other page again. These are the lessons that we have learned out of the contract, gentlemen. And as I said, we have a very robust contract going by the lessons we have learned from the previous contract. Thank you.
Ali, thank you very much for that. We can spend the whole day talking about that case. Can I now move on to Q&A? There are quite a few questions which have come in. Before we do that, there is a second poll, so I invite you all to vote on that. Steve, could we have the poll, please? Okay, so the poll says, do African arbitrators, institutions, and practitioners have enough capacity to handle multi-million-dollar investor-state disputes in Africa? Yes, absolutely, or yes, but needs more capacity, or no. Please go ahead and vote. I'm not allowed to vote, but my vote would lie with the first one. Not that I'm trying to swing the vote. Steve, if we can have the results up as well, please. Okay, so there is good confidence in our capacity in Africa to handle these types of disputes, but we need a little bit more learning and development. Thank you for that. EAC, please take note for further areas of seminar series, please. Thank you. Okay, so we now come on to Q&A. There's quite a few questions which have come in, so let me take them in turn. The first one by Faiza. Why is Somalia and Eritrea missed off discussions when we talk about East Africa? Surely we should be mindful and aware of developments beyond the big players. I agree, Faiza. I think we do need to have probably a separate session on new developing emerging countries when it comes to oil, gas, and other areas. And I think this is something which EAC certainly will take into account. There are a number of initiatives, of course, with new petroleum producers. For example, the Commonwealth Secretariat organizes 3 to 4 day trainings every year, every other year for these countries to come together from not just Africa, but around the world. And they spend 4 or 5 days in a particular country being trained by government, by lawyers, by the host nations. And it's a very important area of development. There is a question by Axel, which I might ask Elodie and Gadi to take about bilateral investment treaties and multilateral investment treaties. Elodie, are you able to perhaps kick off on that one, followed by Gadi?
Yeah. I think the studies have gone both ways as to the effect of BITs on investment. What I would say, like from experience with IOCs, is that it's increasingly something taken into account. And if there is no BIT, increasingly now they structure. And if there is no BIT, no way to structure, because there's just not enough BITs available to do that exercise, I think it's just a risk, because it means you're probably left only with a contract with a host government or an NOC with arbitration seated in the country. And that factors in the negotiation of the contract because it's an increased risk.
Thank you. Gadi, do you have any view on that, please?
No view on whether there are stats on this. I'm not aware, but what I do see from the developer is that it's not typically something they put at the forefront. Maybe the decision is made before they even engage with the government, which is a possibility. I know the New York Convention is really important, obviously, but beyond that, typically it's much more the credible message of the government and the way they approach their sector and a track record that will definitely be on top of it. But for the treaties, I've not seen that as a critical point yet.
Okay, thank you. There is another question by Falasha Deali. She says, as at May 2021, pipeline vandalization and bunkering is increasingly becoming prevalent along pipelines, which is grossly affecting sale to off-takers. Are there any steps an NPC can take to curb this increase in vandalization and theft of crude oil? How can contractual agreements incorporate these risks, and what role can arbitration play? Khalid, I guess this question is aimed at you. Perhaps you can take a crack at it, please.
Thank you very much, Kamal. Well, the issue of pipeline vandalism is a security issue. It's not purely around NNPC. So if a pipeline is vandalized and products such as crude or gas or any other component is stolen, NNPC is more or less they lose them. But on the security aspect, I tend to say that that's a national security issue. But coming back to NNPC, NNPC has improved in its pipeline laying. If you see the kind of pipeline that have been laid, for instance, in the AKK project, we're talking about 45-inch pipeline in terms of thickness, and they go underground. They're not just on the surface, like as against the ones that were laid in the 70s. And then, of course, we have the CCTVs, we have the surveillance cameras, we have the surveillance security that are also all around the areas. You will know that NNPC has taken robust steps in terms of ensuring that the security has improved. But as I said earlier, this is a major security issue that the federal government can handle than NNPC. Now, on the issue of clauses, the clauses that are being accommodated in the contract, we usually have accommodation for things like this. They have the force majeure, for instance, on issues that parties can jointly not be able to control or that are beyond their control. Fire outbreak, pipeline vandalism could be one of those. So we have not been having arbitration surrounding pipeline vandalism because most of the contracts that we have around that area could be local contracts that can be handled in terms of mediation or settlement or ultimately litigation, then going into robust arbitration, which is very time consuming. So I think the federal government is working roundly around that. Thank you.
Thank you, Khalid. The next question is from Leyu Temeru from Addis. What would be your advice with regard to allowing special purpose vehicles, with regard to defining investment in BITs and the investment protocol of the AFCFTA? Perhaps, Elodie, you could take this. Have you seen, I'm sure you have seen SPVs being set up to take advantage of bits and MIT. Can you share some thoughts?
Yeah, so I mean, I would expect like the investment protocol of the AFCFTA to follow like the new generation investment treaties and like the Nigeria-Morocco BIT, which is kind of not enforced, but kind of representative of this trend on the continent, or the SADC investment protocol, not enforced as well, but kind of go in the same direction in terms of where the BIT, the investment treaty drafting is going on the continent. So these new treaties would have language to exclude the treaty shopping, the special purpose vehicle usually. So for instance, the Morocco and Nigeria investment treaty, I think requires a principal place of business or the center of economic activity in the home state. So obviously, if you have a special purpose vehicle, that's a definition difficult to meet. So I would expect, new treaties being entered on the continent and the AFCFTA investment protocol to follow that line and preclude that kind of practice.
Thank you, Annie. This is a very important question because we have countless examples of treaty shopping, forum shopping in various awards that we have seen documented on websites and litigated in the courts as well. Lady, thank you for that. The next question is Suzanne Rattray. Is the investment structuring that Elodie discussed comparable with tax avoidance and incompatible with sustainable development obligations? Perhaps Elodie and Gadi, you could take those and have two different perspectives, please.
Yeah, on the tax part, no, it's done in conjunction with tax advisors, and it's really fully tax compliant, tax legislations compliant. On sustainable development, the first generation treaties, which most African treaties in force are, do not contain the sustainable development language. So this practice wouldn't be incompatible in that sense. The sustainable development language is found in a new treaty, like the Nigeria-Morocco BIT, like the SADC investment protocol, but which as part of that new approach of basically balancing more the right of the investor and the host state, there would be specific language in the definition of investor to preclude treaty shopping. But I would say as it stands under first generation investment treaty, which do not have any language precluding it and do not have any sustainable development related obligation which would preclude it, that's not an issue.
Thank you. Gadi, do you have any thoughts on that?
Yeah, actually, the answer is vastly different in the power sector. And you have to understand how the project finance work for this sector, where I actually typically advise the government to give as much tax exemption as possible. Because if you do understand how the developer construct the tariff price, even in a bid setting, so in a competitive bid setting, they will incorporate any tax cost into the tariff ultimately paid by the utility. So what happens ultimately is that the country will pay some financial costs on the taxes that they receive throughout the course of the relationship between the private sector and the utility. So ultimately, since every single tax and import duties will be incorporated in the tariff, which is paid by the utility and paid by the population, it's actually better to keep it as lean as possible tax-wise, to only pay the cost of the power plant plus an agreed or competitively defined return on the equity of the investor.
Thank you, Gadi. I'm going to just jump one or two and come to a question which Rukia has asked to Khalid and to Gadi. For young lawyers seeking to join the energy sector, is it better for one to pursue a master's in energy law, or would they rather learn on the job? Given Khalid and Gadi, you have many decades of experience. Perhaps Khalid, you can kick off with that, and followed by Gadi.
Yes, Kamal. I think both suggestions are right. You can have the postgraduate studies in energy, so that you could have additional qualifications. You can also build on the career with your basic university degree and a lot of courses, because when you start the career with your basic qualification, the organization will still sponsor you and ensure that you attain all the experiences that you need to be able to contend with the challenges in the oil and gas industry. I do know of several oil and gas industry experts that have risen to the very highest position, and Mr. Kamal can testify to that fact. Who, after graduation, secured the job, but you could mistake them for professors of oil and gas. So either of the two is important. If you want to go for postgraduate, you can do that, but also know that if you start the career, the organization will keep sponsoring you and training you until you become an expert in the oil and gas industry.
Thank you.
There is not much to add to this. That was a great answer. Again, I don't think there is one way. There are multiple ways to get there. What's really interesting is now so much information is already available. So be curious, keep reading, do your own education on top of any other opportunities you get. And there are a lot of different courses that are free. ELSF Academy is one of which, and as soon as you become credible and coherent in conversation, people will give you opportunities. So definitely.
Thank you. And staying with you for a moment, Gadi, there's a question from Demi Lemo, who says, considering its criticisms, do you think that third-party funding should be used as a tool in addressing the lack of capacity issues which African nations face when faced with arbitration claims? Now, ELSF do provide funding to certain types of defenses which governments have to put up, which is a great initiative. Gadi, could we have your perspective on other types of funders and what you think as ELSF of those?
I mean, it's difficult. I mean, the ELSF does help and provide support, but in really narrow cases, as you said, and we need to be comfortable that this is something we can support the government with. If that's available, definitely do it. We do provide some of the best lawyers to defend the government or to represent the government. Third-party funding, it would be better when if each government on this continent would have funds to have a decent representation, but we know it's not the case. So I would say it's a case by case, but failure to appear and not respond to service and failure to appear in court or during the arbitration case is so detrimental. It is not. It should be, but not it should be, but it's not the arbitrator role to plead the case of the government. So it becomes quite difficult when the contract is obviously unbalanced, but ultimately an award is rendered because of the failure to appear. So I do believe it has a role to play. Hopefully we'll get to a place where government will have the funds to represent themselves, because that's the proper way.
Thank you. Elodie, I wondered if you had a perspective on that.
Yeah, I mean, the difficulty, I think, well, if the government is on the respondent side, I think there is a difficulty for third-party funder, because ultimately they want a share of the profit, so there will need to be a counterclaim or some money potentially at the end for the government. So I think that's where there's a difficulty for governments to secure third-party funding, because they would often, at the investment treaty, they would be respondent. So when they are claimant, I think that's that becomes much more an option. And what I've said, I mean, there is some backlash about third-party funding, but from experience, I think third-party funders ultimately want a case which has a good chance of success, because they won't make money unless you win. So they are not going to be funding frivolous claims, because they would just lose their money. So I think there is like a more reasonable economic approach, and it's there are quite a lot of options now of good funders, and they will do their diligence on potential claims and decide to fund or not, and that's definitely something to consider.
Thank you. I think we can just address one last question before we end. We're just over by 3 minutes. A question which I'll summarize. Tohib Amuda has asked, is the role of political influence in energy projects and that leading to disputes? And we have, of course, seen a number of those in recent years. how does one minimize this? Perhaps each of you can just give 30 seconds on your perspective, starting with perhaps LOD, followed by Khalid and Gadi to end.
Yeah, I think, I mean, one thing is to be, for governments to be aware of the potential consequences when they are going to interfere with a contract, or at least, like, we're not talking about like the general legislation change necessarily, but like terminating a contract on something really abrupt or giving in to the competitor, these kind of things. Basically having some awareness of the potential consequences and legal claims, including investment treaty, which maybe, and if the person was acting on behalf of the government, then okay, I mean, the state, the government would be basically the responsible and the respondent in this. So some awareness of the potential consequences.
Thank you. Khalid, your perspective, please.
Just to corroborate what Dulak said on the consequences, the only thing I need to say is the consequences awareness does not reside with government alone. It also resides with the executors of these projects. They should know that there's a difference between responsibility and liability, and that responsibility does not abdicate liability. If you are responsible, then you should also know that you could as well be liable. So it's important to try to become very strict when it comes to compliances. We've seen that in the case of IPCO, where a bid came in late, and there were some influences regarding the submission of those bids. And then, of course, like Mr. Kamal said earlier, there were also a lot of political influences that will have made the case to have been swayed otherwise. But we were so consistent until we got the award set aside. So the lesson there is that the consequences should not just reside with the government, but the contract managers should know that there is criminal consequences and civil consequences that will follow, and they should try to be very strict.
Thank you. Gadi, let's end with your thoughts, please.
Yeah, there's not much to add. The only thing I would say is it's a broad concept, political interference, and sometimes it can be justified when you have a sector that is actually going bankrupt, if I can say it that way. But we have a lot of utilities with really weak financials across the African power sectors. So it is sometimes the role of the government to step up, but the importance is to do it as in a sector-wide manner and to have a discussion with the private sector participants to provide something that is fair and coherent, and often it's not done that way, and that leads to claims. But ultimately, I think the rest was said already by my two colleagues.
Thank you very much. I'm afraid we've run out of time for questions. I'm going to hand over now to Warimu to wrap up. Thank you very much to all the panelists.
Thank you. Thank you very much, Kamal, for taking us through such a capable panel. Energy.
Oh, I think we've lost Warimu momentarily. She's back. You are on mute, Warimu.
Thank you. I believe it is because we had run out of the allocated time. Thank you, everybody who joined us. Thank you, Kamal, for taking us through a great session with the expert speakers. Special thanks to you, Gadi, Elodie, Khalid, for taking us through your presentations. Thank you, Kamal, for doing a brilliant job. And also special thanks to Dr. Wilfred Mutubwa, who could not join us, but had prepared an excellent presentation. And we've actually addressed some of what he was meant to speak on in some of the polls that we've discussed, where we discussed whether, Africa has the capacity. And we definitely, the vote was that, the highest vote was that we need more capacity, but I believe that we do have the capacity, and, we should always steadily improve. Thank you, the delegates who joined in from over 25 countries, very many companies and institutions. We really depend on you to have interest in the topics that we bring up, in the topical issues and in the conference, so that we can keep it running. Thank you to my committee members, Agnes Gitau, Elodie Dulak, Leyu Tameru. Thank you for continuing the good work for the last 8 years as we look for other 8 years. For everyone who has joined us, please remember we have our annual conference on the 27th to the 29th of October 2021. Details will be circulated, and we shall discuss energy, infrastructure, construction, and ACFTA, many other issues that have come up. So please join us. We shall also have a special training session for the young arbitrators as we had last year. So with that, I say asanteni sana, kwaheri, have a good day.